Um, my name is Ilan Wiesel. I'm a lecturer at the School of Geography at the University of Melbourne, and I'm one of the conveners of the University of Melbourne Affordable Housing Hallmark initiative, which has initiated and funded this seminar. This is the last seminar of a seminar series. And the topics of today, housing for people with disabilities, it's a topic that I have a long-standing interest in. And I hope you all enjoy the session today. Very warm welcome again. Thank you for joining us on a very, I guess, nerve-wracking day for everyone. I'm sure I'm not alone following the election results coming in from the US. I'm sure you all have some iPads showing you the map of the US and the different states there. I do want to open the session with an acknowledgement of country. We're gathered, I guess, from many parts of Australia, and some of you might be coming from outside of Australia. So I'll just talk about where I live and work on the lands of the Wurundjeri people of the Kulin Nation. And I wish to acknowledge them as traditional owners of this land. And I'd like to pay my respect to their elders, past, present, and emerging, and extend my respect to Aboriginal elders of other communities who may be joining our seminar today. The aim of this seminar series is to bring together interdisciplinary perspectives on housing affordability and accessibility. And today's seminar is focused on regulations surrounding housing for people with disability. We have 4 fantastic panelists today: Andrew Martell, Owen Jordan, Shane Leonard, and Tony Rutherford, who I'll introduce shortly. The way the session is structured, each of our speakers will speak for about 7 minutes, and then we'll have a panel discussion and a Q&A. So you're invited to submit your questions through the Q&A tool on Zoom. You can submit your question at any time as it pops in your head, and we'll get to those questions at the final part of the session, the Q&A session. The seminar is being recorded, and the recording will be made available soon after the seminar. Before I introduce our first speaker, I do want to thank Holly Jones, who's done a wonderful job organizing the seminar and technical support and administrative support and conceptual support. So thank you, Holly. And then without any further ado, I'd like to introduce our very first speaker. It's a great pleasure to introduce Andrew Martell. Andrew is a lecturer in construction management and architecture. His research is focused on housing for people with disability, and a particular focus of Andrew's research is on the challenges of policy implementation and I guess the challenges of translating policy intent to actual outcomes on the ground for people with disability. And Andrew has a kind of a very in-depth understanding of architecture and design, but also the construction industry in Australia. And that sort of offers a very original and extremely important perspective and contribution to recent debates about housing for people with disability. So thank you, Andrew, and looking forward to hear your talk.
Thank you. Thanks, Ilan. I'd also just like to acknowledge that the panel discussion we're having today is happening on Indigenous land. Let me just share my screen. Apologies, it takes a few seconds to actually load up. More than a few seconds sometimes. There we go. I'm seeing that, so I hope that all you can as well.
Yeah, all good.
Thank you. Excuse me. So thank you for coming. As Ilan said, there's a lot going on in the world today, and so we're really grateful that you've taken the time to come and listen to a talk about regulations. Not often the most exciting of topics for some, but a really important topic around, or really important component around a very important topic, which is how do we properly house and provide housing for people with a disability, and even more profoundly, I think maybe thinking about, are homes where people with disability live homes, or are they facilities and institutions? And sometimes that is blurred, particularly in the regulations. So we're going to have a bit of a discussion around that today. I'm going to talk about the research project that we are doing, and then I will leave it up to my industry partners to sort of flesh out some of their personal experience. Okay, so the research project, what are we going to do? Well, I guess to start and provide a little bit of context around the provision of housing for people with a disability, we need to start with the NDIS. The NDIS has radically changed how we deliver disability services across all elements of disability in the community. And that includes the housing element as well. And so while in itself the NDIS is not a housing provider, it's set up in a way that there is an emphasis on people being able to live in the community, which is a big change, a very, very big and a very welcome change, away from institutions, from facilities, from group homes, and actually being able to live wherever people want in the community and have their services come to them. As I mentioned, the NDIS itself is not a housing provider, although you'll hear a little bit about SDA and some of the housing components in it, but really the emphasis of it is it wants the private sector to be the driver of supply of the very many new homes that we need for people with a disability. The other thing to think about a little bit when we're talking about people with disability and their sort of living arrangements or their home is that there's quite a complex relationship between home and work for people with a disability. I think we've all found, being in lockdown in Melbourne, for those of you who are Melbourneites, that working from home has for all of us complicated the relationship between home and work, but in particular for people with a disability, and about 6% roughly of the Australian population has a relatively severe disability, and so quite often support workers will come into their home. So their home is literally a place of work as well as their home, and regulation follows you around in those kind of situations. So the need to provide a safe working environment for people who are working, the relationship with tenancies and for people who are renting. So there's a range of things that get complicated with the relationship between home and work, and we'll touch on some of those in the presentation today. The other thing to remember is that housing itself is a regulated industry. We have building codes and laws and things that we must do, and housing for people with a disability has additional regulation that goes over the top of that. So it's quite a complex regulatory environment for people to navigate. So what kind of regulation, broadly speaking, impacts on housing provision for people with disabilities? The building regulations, of course, you'll all be familiar with the National Construction Code and those kinds of things. Regulations, as I sort of touched on, around disability also impact in this sphere through various reasons, through various vehicles like the NDIS, like the various disability acts that we have. As I mentioned, tenancy regulations, not all people with a disability clearly will own their own home. Some will rent with other people with a disability, with people without a disability. And so tenancy regulations come into it and are important. And then on a broader level, there are human rights regulations as well. Australia is a signatory to the UN Charter on the rights of people with a disability. And that brings certain responsibilities with it as well. So we have all these different spheres, all with their own regulations that interact in the housing environment. So this is not an exhaustive list, but this is some of the ones that I could fit on the screen at a reasonable font size. So as you can see up the top there, the National Construction Code, clearly, when you're building houses, you need to follow that. Building Act in Victoria, then building regulations that come out of that, and those regulations then introduce the National Construction Code in here. Federally, Disability Discrimination Act, which is really a rights-based act, but in order to implement it, the Disability Access to Premises standards came in 2010, and they, like similar to the building code, are performance-based. So there's an interesting juxtaposition of rights-based regulation and performance-based regulation and how they interact with each other. That then brings in some Australian standards. You see the 1428 that's associated with access to premises. There are a few others to do with accessible car parking and so forth. It's interesting to remember that the Disability Discrimination Act and the Access to Premises sits outside of the National Construction Code. So it's not part of the Building Code of Australia. It's a different regulation, but it affects the way we build houses for people with a disability. Then you have the NDIS itself and the rules around SDAs, Specialist Disability Accommodation. Those are moving feasts. Those are changed. You see we're at the 2020 ones at the moment. The NDIS amendment to include that came in 2018. The most recent design standard was October 2019. Victoria has its own Disability Act. Anytime you're building housing, you're of course subject to the Planning and Environmental Act because you need to have planning permission. Residential Tenancies Act, as we've sort of touched on a little bit, that was modified in 2019, and I think this will be touched on a little bit later in the presentation, to include the NDIS SDA provisions and sort of include ideas of people with a disability being residential tenants. And as we touched on with people coming into homes to work, the Occupational Health and Safety Act and the associated regulation. So that's not an exhaustive list, but it just shows you the sort of types of rules and that are apply in this field. So what are we trying to do? What are we trying to do with the actual project? Well, what we're trying to look at is how do this variety of legal responsibilities in the construction field, the rights field, and tenancy provision spheres interact to either support or inhibit investment in new dwellings designed to accommodate people with disabilities. Additionally, sort of which set of those responsibilities have legal precedence over the others? They're reasonably blurry, I think. We're hoping to sort of find that out a little bit more. And so which ones of those should be used as the overriding guide for outcomes for policies for people with disabilities? And importantly, what can be done and by whom to clarify the governance environment around this housing sector that can facilitate effective private sector investment, which is what the NDIS envisions. What are we expected to find? And we just started this project, so we don't have any findings at the moment. They will hopefully unfold over the next sort of 10 or 12 months. But really, we hope to shed some light on the complex interaction between rights-based and performance-based policy provisions that influence quality and cost of new housing for people with disabilities. So these are issues that have material effects both on the quality of the housing that we're building for people with disabilities, but also on the cost, and the cost has really serious implications. We want to provide a practical point of reference for prospective market entrants coming in and to influence future policy directions of the government. And we're really looking at an opportunity. We think with this project, with a strong industry engagement that we have, there's an opportunity for peer-to-peer engagement from stakeholders from government, development, finance, law, and the not-for-profit sectors in this emerging market. And we think that that kind of stuff will really help, again, to clarify some of the uncertainties that are there. So that's me. I'll stop screen sharing and hand over to the next speaker.
Thank you very much, Andrew. That's a very useful overview of the very wide array of regulation in this sector. Our next speaker today is Owen Jordan. He's the founder and the managing director of Iwara Projects and the deputy chair of the SDA Alliance. Owen has built the Iwara Projects as a quality provider of customized disability housing solutions to NDIS participants to help them increase independence and improve quality of life. And Owen brings in-depth knowledge of the technical issues facing developers and investors in the SDA sector. Thank you very much, Owen, for joining us today, and over to you.
Thank you very much, Ilan. Let's see if I can share my slides. So, look, thank you everyone for your time, and especially a thank you to the Hallmark Institute for funding this project. So it's an incredibly complex environment, as Andrew mentioned, and I've known Andrew for a number of years, and when I approached Andrew with this issue we have, it was great that Andrew was engaged in sort of getting this project stood up, and with the support from Hallmark, it's greatly appreciated. So if we just have a look for a moment at the environment from a developer's perspective, it's extraordinarily complex. We know that Andrews has highlighted some of that legislation and regulation that underpins developing disability housing. It's actually much more than that. it's quite interesting when people say to me, what should I be aware of when developing disability housing? I say, where do I start? There's quite a lot, and I think Andrew highlighted that very well. 4 years ago, when we started down this path of developing disability housing, it became very apparent very quickly that the systems that are being developed, whilst fabulous with wonderful intent, are fairly siloed, and they don't necessarily work across each other. As I've mentioned there on the slide, siloed systems such that the National Construction Code doesn't necessarily talk to the Residential Tenancies Act, and access standards don't necessarily talk to other things. We've got workplace safety. We've got all these different, I guess, areas of regulation to consider, and they don't necessarily work across each other. And when one changes, it can have unintended consequences on another, which I'll explain in a couple of minutes. Over and above all of that complexity, things vary by state. So we've got the National Construction Code variances by state. We've got residential tenancy law variances by state, workplace law variances by state. That goes to add to the complexity as well. And when we're providing a potentially national solution as a national provider with the national system of the NDIS, these individual state variances can actually make it really complicated for developers in Australia. As Andrew touched on, there's a lack of clarity as to disability housing and whether under the National Construction Code it should be classified as what I call a facility or a dwelling. And there's some issues with that lack of clarity, and the big one is different interpretations by building surveyors or building certifiers in the other states. Because it's not black and white, and because of this new environment's being created, we actually find that the same dwelling can be considered quite differently by different building certifiers. Over and above that, in different states, there's kind of a legacy of what was traditionally done. So if we're talking building classes, and Shane will talk a bit more about this, there's a bit of a legacy in Victoria that building classes for disability housing for residents with multiple residents with disability might have been class 3. But in the other states, it might have been considered class 1B, and that's just a carryover of the legacy from those states. We've also got quite different interpretations of what's called sole occupancy units, and I won't go into that. I'll let Shane talk about that. But that creates both of those things. The building classes and the sole occupancy unit classifications create significantly different buildings when you're building them, rightly or wrongly. And what we want to do is we want to tease this apart. This project is about saying, well, what's right? What should we be doing? Because at the moment, it isn't clear. Right. Oops, so next slide. So what's happening as a result? Well, as a result, in the market at the moment, we're getting vastly different qualities of construction. We're having some buildings built to extremely high level of compliance with a lot of considerations for things like fire and access. And we're getting other buildings built to a very low quality of construction, which potentially might put some residents at risk. And there's very different views on what's right. And this lack of clarity is something that we need to explore. Clearly putting people's lives at risk is not right, and we mustn't do it. But if we over-engineer a building, we might make it cost prohibitive to produce. And the market isn't stimulated the way that the NDIS intended with funding for disability housing. There's also a risk that if we are not careful about how we design buildings, they can become less home-like and institutional in appearance. And that's not something that we want. And I'll show you a case study on that in a minute. Because of the variances by state, the classifications varying by state, generally speaking, the cost of construction is significantly different in Victoria, for example, compared to other states. And that's detracting from investment in Victoria, where the SDA payments from the NDIS, for example, might be the same in each state or somewhat similar, but the cost of construction is quite different. And that's something we need to pull apart to find out what's the right regulatory environment and how should the regulations be interpreted. The interrelated frameworks are not well understood. For example, in Victoria, there was changes last year to Residential Tenancies Act, which actually has an effect on the National Construction Code, particularly around what we call sole occupancy units. And that's not well understood by the market. because of this lack of clarity, we've got some well-intended developers making errors in their developments, which we don't want. And that's can lead to some very, very costly mistakes. And last but certainly not least, very importantly, we need to overlay the views of people with disability on this in this discussion to try and find what's right, because we don't know at the moment. So I'll just finish with a quick case study. So this is a modular dwelling. It's a single resident, 1-bedroom modular dwelling, built in 2 sections, transported to site. This one was actually on display last year as a demonstration project. This very unit next week's being moved to a site for permanent installation. The building surveyor who's overseeing this considered this building to be a Class 3 dwelling. And as Shane will mention, this has some serious implications for this dwelling. And one of them, and one of the very important ones, is that it's actually going to result in this being a less home-like environment. Now, whether that's right or wrong, I'm not sure. I'm not the expert. But if I just show you what's happened, this building is now going to be installed on site. This is the floor plan. There's a carer's room next to it. And under the carport at the front door is going to be an accessible car parking space, more akin to being used in a commercial or a facility environment, with brightly coloured yellow lines with a bollard. Now, it's done for a reason, because the Class 3 requirements say this is what you should do. But we really need to ask ourselves, I think, is this right? On a very small home, we've just turned what is a lovely residential home into something a bit different. And I think that should be explored. Ilan, I think that's it.
Thank you, Owen. Thanks so much. We've got lots of questions. We'll leave those to the Q&A part of the session. And I also remind all our attendees, you can also feel free to just pop up your questions on the Q&A button in the bottom of your Zoom window. And I'd like to introduce now Shane Leonard. Thank you, Shane, for joining us. Shane Leonard is a director at Philip Chun. He has 32 years of experience in building surveying, and that extends from residential, commercial, healthcare buildings to industrial developments. He's been involved in some of the landmark projects that many of you would know, including the MCG, Theatre Stadium, Eureka Tower, Melbourne office towers at 150 and 567 Collins Street, and several multi-storey residential towers and precincts. Shane frequently prepares, expert opinions reports relating to the building code law, and has given evidence in High Court, Supreme Court, County Court, and VCAT hearings. He served on the Buildings Appeal Board for more than 11 years, with 8 of those being in the position of Deputy Chair. So a lot of experience relevant to our topic today, and I'm keen to hear what you've got to tell us, Shane. Thank you.
Thanks, Ilan. I'll just share my screen now. Can everyone see that? Gather that's the case. So essentially...
We can't see your screen yet, Shane. Could you please share again?
Sorry. Thanks, Holly.
Perfect.
All good, thank you. So essentially, I'll probably be raising more questions and giving answers today, essentially, because this particular project is going to delve into what we have and haven't got at the moment. And currently we don't have a lot for a building surveyor to implement from a regulatory perspective. As Andrew mentioned, the 4 essential legislative requirements that for Victoria specific, and this will be a little bit Victorian centric. However, as you're aware, each state has their own building legislation, which does complicate things a little bit. We're really 7 countries in one, but we'll talk about Victoria specifically today. So there's the Building Act, which is essentially the Parliamentary Act, which allows the creation of the building regulations, recently been amended in 2018, which calls up the National Construction Code, which is also known as the Building Code of Australia. National Construction Code actually encompasses building and plumbing regulations and is made up into 3 parts, essentially. Volume 1 is commercial properties, basically anything from a block of flats through to public buildings, stadiums, airports, etc. Part 2 is the residential part, which is specifically for Class 1 buildings, being your typical house, and Class 10 buildings, which are your typical outbuildings, but that also extends to public facilities in parks like sanitary facilities, etc. But small outbuildings, non-habitable. And Part 3 is the plumbing, which I don't know much about, to be honest. The Australian Construction Code parts, or volumes 1 and 2, do call up Australian standards, and specifically related to access for people with disabilities is the suite of AS 1428 parts 1 to 4. However, for the purposes of the building code, it is only Australian standard AS 1428 part 1 essentially that's called up, and there are a few reference parts in part 1 that refer to part 2 to do with tactile indicators, etc. So that's the legislation that I'm bound by as a building surveyor. Now, the role of a building surveyor essentially is to assess the documentation for building permit, issue a building permit, carry out inspections during the construction phase at periods known as mandatory notification stages. They're essentially structurally related, with the exception of the final inspection, which is carried out prior to a issue of an occupancy permit. And you need an occupancy permit to occupy any building. If you don't have one, you're in breach. So once all those phases are carried out, occupancy permits issued, buildings allowed to be occupied, and essentially life goes on. Section 24 of the Act, I've raised this just because as a building surveyor, this limits me in a sense that I'm not allowed to provide or require a greater standard or a lesser standard than that's set out by the Building Act and Building Regulations. So by way of example, a standard detached house out in the suburbs doesn't require ramp entry. It could have 35 steps up to the front entry with a few landings. I can't turn around and go, well, how could a person in a wheelchair possibly get to the front door of this house? I want you to put a ramp in. That's just not within my gamut of powers. So it boils down to the industry recognising that that might be a necessity for certain applications and provide that information themselves, or provide that type of construction themselves. I can't necessarily impose it. Now, just to give you a quick rundown on classification of buildings. So Class 1A, as I mentioned, is your dwelling. Detached essentially could be a party wall dwelling, a row house, but essentially is a fully contained dwelling. 1B is a dwelling that can contain up to 12 unrelated people, but is no greater than 300 square metres. And there are specific requirements for people with a disability if you do build a Class 1B building. And essentially that is to have access to common areas, access to maybe one bedroom in a house where you've got up to 10 bedrooms, and also access to sanitary facilities such as showers and ablution facilities. A Class 2 is an apartment, typical block of flats essentially, as we know down in Docklands. A classic example of Class 2 buildings, fully self-contained, have their own laundries, have their own bathrooms, and you can cook your own meals, etc. Class 3 is more akin to a hotel or a motel. Some of the low-level accommodation houses, boarding houses, etc., are Class 3 buildings. Now, Class 3 buildings also have specific requirements in terms of numbers of bedrooms that should be available, and access to kitchens, common areas such as games rooms, pool rooms, pools and outdoor areas, kitchens, etc. Also need to be accessible under the regulations. Classes 4 to 8, a Class 4 is a residential building, but it's attached to another classification, has no requirements for accessibility. 5, 6, 7 and 8 are essentially commercial and industrial buildings, do have access requirements for people with for work purposes, but aren't residential buildings, so there's no sleeping accommodation in those. Class 9 are your public buildings, theatres, etc. They too have obviously accessible requirements, but again, there's no sleeping there. other than hospitals, potentially Class 9A buildings, come with a whole host of accessible requirements, as you'd understand. Class 10 buildings, as I mentioned before, are facilities in parks and public swimming pools, etc., that do have some minor accessible requirements for facilities, etc. Okay, so just to put a bit of a sort of an understanding on what Owen spoke about with that dwelling being determined as a Class 3, the role of the relevant building surveyor is to make a determination as to the classification of the building based essentially on what it best resembles. So a lot of them obviously clearly fit into the boxes quite neatly, but there are a few that don't. This building surveyor that Owen's quoted, I'm unaware of, but has decided that it's a doubtful classification to have that particular facility plonked on a block of land somewhere and not call it a house, and has subsequently classified it as a Class 3 building, which in turn does set up other requirements to do with parking facilities, access to the dwelling, facilities within the dwelling, circulation spaces, and a whole host of other things that would essentially make the building more institutional or than a dwelling, and perhaps not really what the market's looking for. But certainly you'll be able to access it quite well. Now, sole occupancy unit, also Owen touched on, the definition of sole occupancy unit is essentially a room or a dwelling that is exclusive to the use of one person from anybody else. So by way of example, if you had a Class 1 building and you decided to rent it out to students or something like that on all completely separate leases for each bedroom, so we had 4 leases on one address, and each bedroom had its own lock on the door, that would essentially create sole occupancy units to every one of those bedrooms. Now, what that does is it not only changes the classification of the building from a Class 1A to a Class 3, it also requires that every sole occupancy unit has fire rating around it and also has acoustic rating around it. So clearly houses aren't built that way, but if we want to head down that track, the current requirements require this additional over-regulation, if you like, or over-prescription that might not be necessary in a general household, that would be for the safety of fire safety and acoustic benefits, I guess, to the people in there. So that's sole occupancy unit. Now, just quickly, apartments and short-term stay, your Airbnbs and those sorts of things are often thought of as hotel rooms or motel rooms. That's not the case. There's been a High Court decision by the Victorian Supreme Court where Melbourne City Council were prosecuting an owner of 4 apartments in a building that had 150 apartments, basically saying that because he was leasing them out on Airbnb for 2 or 3 days a week, they become Class 3 buildings and they should have full-blown accessibility requirements and fire requirements associated with what we'd normally have for a major hotel like a Hilton hotel or something like that. The judges in that appeal determined that as long as the sole occupancy unit essentially was fully self-contained, that is that it has laundry facilities, sleeping, cooking, and ablution facilities within its own walls, it remains a Class 2. It doesn't matter if you rent it out for a day or a month or a year, it's always going to be a Class 2. So on those circumstances, there are no requirements for people with disabilities in those particular buildings. Really, what it boils down to is unless your building is Class 1B or Class 3 from a residential perspective, the current BCA or NCC do not prescribe any further requirements for houses, flats or anything like that. It's really, there's a whole gamut of information out there that says what we should do and could do and make things more accessible for people with disabilities, but there's no mandatory requirement for a building surveyor to enforce those. They could potentially be brought in through planning legislation. I'm unaware of whether that would actually be legitimate, but essentially from a building surveying perspective, we're limited. If they fall outside those classes, then we can't enforce anything further. So just in closing, from my perspective, other than a significant change to the building code, which I understand the Australian Building Codes Board are currently looking at and have done some regulatory impact statements and some drafts to enhance accessibility to the general housing stock that we have, is that we need to create a culture that perhaps has more incentives, maybe tax incentives for builders that build dwellings that are more accessible, provide a greater ability to build more dwellings where a certain aspect or a certain number of those are fully accessible, and the governments perhaps need to step in and regulate, because unless there's some incentive or regulatory requirement, it really boils down to the developers, and unless you're a developer with good morals, then essentially you may not tend to want to create this type of environment for people with disabilities. So that's about me, Alan. Thank you.
Thanks so much, Shane. I think the further we hear, the more into the depth of complexity we go. Our next speaker today is Tony Rutherford, a partner at law firm Mills Oakley with a specialization in property and construction, and recently acted as for a range of developers, disability service providers, and community housing providers in relation to the structuring, financing, and development of social and affordable housing and specialist disability accommodation SDA projects in New South Wales, Victoria, and Queensland. Thank you, Tony, for joining us today. Over to you.
Thank you, Alan. I'm just trying to make sure that I can share my screen here. Is that on the screen, Holly?
Yep, we've got it.
Okay, great. I think I'll probably be echoing some of the comments that have been made by the prior speakers in relation to the inconsistency of the various regulations and legislation. So in terms of, there are a whole bunch of issues to cover from a legal perspective. For today's purposes, I'll be covering tenancy legislation in particular. Obviously, prior to the NDIS, there was a mechanism or a structure, a statutory structure that focused on the provision of care really by disability services providers. So the accommodation and the care was completely linked, and so legislation around housing people with a disability was based on that assumption. So the NDIS, obviously, once that's come into play, that's thrown everything into a state of flux, because the various pieces of legislation that deal with tenancy, amongst other things, were focused on that joint provision of care and accommodation, which the NDIS is not consistent with, because it's based on this concept of choice and control and being able to choose a place to live in and not have that link necessarily to a care provider. So there's been a bit of a conflict there. Another example is where there are kind of head leases for multiple kind of dwellings that in turn are leased to individuals. So if you think about the idea of having 10 or 15 apartments or rooms that might be head leased by an SDA provider and then in turn subleased to tenants, that was never kind of contemplated under the tenancy legislation in each of the states. So sitting above, I'll focus on Victoria to start with, but so obviously once the NDIS came in, as an order of kind of hierarchy in terms of the way that SDA was to be dealt with, and I should highlight that, I'll put housing for, non-SDA disability housing to one side for now. But in terms of SDA, obviously, you've got the Ndis Act that came into force in 2013. And then there's a whole bunch of policy or other documents that sit below that, including the SDA rules, the SDA price guide, which was mentioned earlier, and then other things like the NDIS registered provider terms of business. So you've already got a suite of documents that guide the way in which SDA must, the standards to which SDA must be designed to, the way in which it will be funded, and then what requirements must be met for somebody to be eligible for SDA funding. So you've already got that kind of federal arrangement there. One of the key things has been the way in which, touching on what I just raised in the prior slide, is the way in which state legislation interacts with that, and in many cases may conflict with that concept. So in Victoria, for example, that conflict was quite clear, where there was, the Disability Act required you to be a registered disability service provider providing accommodation to persons with a disability. And quite expressly, the Residential Tenancies Act was determined not to apply. So under the Disability Act, the disability services provider was responsible for tenancy management and board services and the like. So there was a clear conflict in Victoria as to how accommodation was going to be provided and care was going to be provided in an NDIS world. So in response to that, Victoria enacted changes to both the Disability Act and the Residential Tenancies Act in Victoria. So now in Victoria, there are specific provisions dealing with SDA under Part 12A of the Residential Tenancies Act. And as part of those amendments, there is a specific form of SDA lease agreement that can be utilised. There is an option to either use the standard form of residential tenancy agreement versus the SDA tenancy agreement. So that is ultimately a question we think that should be determined by the person who's going to be residing in the premises. But even that is not clear in the legislation. So I might just touch on this. So even in Victoria, after they've actually gone to the effort to amend their legislation to deal with SDA specifically, there are still significant issues in terms of the way that the amendments are drafted, and then the flow-on consequences of that. So as I've stated there, the structure is still imperfect, and there are various cases where disability service providers who are operating group homes have had to re-gazette the houses they've been operating because of the confusion that arose from the need to have these other agreements in place, or other forms of agreements in place. So I think they're still working through that at the moment. There are other components of the regulations or the rules of Victoria that relate to tenancy that have caused issues. So the way that the Act is drafted, or the amendments to the Act are drafted, they require that the SDA provider either be a headlessee or headless, or an owner of the premises. So what that means is the owner entering into the tenancy agreement with the person with a disability, they have to be a registered SDA provider, or they have to enter into a head lease with an entity that's an SDA provider. And that may be well and good but in many cases, the owner of the property is not interested in being an SDA provider, and nor should they. And that's particularly the case where, for example, you have a property fund, and there are significant property funds moving into the sector that are owners of these SDA dwellings, and they don't have experience or the qualifications to be dealing with tenants with a disability, which is why you would bring in the SDA provider. But there are tax consequences, in particular GST, that may arise from having to have a head lease in place versus, for example, a property management agreement. So all of these things need to be taken into account, and I suspect there will be further amendments to the legislation in Victoria as we move forward. It is worth noting that despite the imperfections in the Victorian legislation, I think it's pretty much, for want of a better term, the gold standard at the moment, because other states are yet to catch up in terms of amending their tenancy legislation to deal with that. So in New South Wales, for example, and a lot of the other states, the RTA, or the tenancy legislation in each of the states, is not really designed for SDA, or at least it's not really designed for a number of people living together, where perhaps a rooming agreement might be more appropriate. And so depending on the type of dwelling, and even in Victoria, the RTA form of agreement may not be the most appropriate form of agreement, because it needs to contemplate rights to a room, but then there will be common areas and the like where that need to be taken into account in terms of the agreement that is entered into. So other states are considering this, and I would expect to see further amendments in relation to their tenancy legislation to deal with SDA. I know that New South Wales have been looking at this. Their preference is to be using the tenancy legislation in each of the states. And that's certainly what we have seen to be the form of agreement utilised in the other states. One of the useful things in relation to the Victorian legislation in particular is that the provisions within the SDA form have tended to form or be the basis for SDA special conditions that are attached to tenancy agreement forms in all of the other states, so that they're a bit more fit for purpose for a person with a disability, and it provides that person with appropriate mechanisms given that they're a vulnerable or may be a vulnerable person. So there's still a fair bit of work to do. There's been some progress made in relation to this. I mean, even if you look at the SDA rules, there have been 2 updates to the SDA rules if we look at federal legislation, and I suspect there will be further amendments to state legislation to try to catch up with this. But it's a bit of a slow-moving beast. So we'll see how the next 12 or 18 months play out in terms of updates to policy and legislation in each of the states. So I think that's it from me, Ilan. So I think we're probably ready to move on to questions.
Thanks so much, Tony. And thanks again to all our speakers. It's a fantastic overview of all the issues surrounding regulation, or not all, but many of the issues surrounding regulation. I invite all the speakers to now turn on your cameras, and we'll have a panel discussion to address some of the questions coming from the audience. And before I go through the Q&A questions that are already starting to appear, I want to ask one very general question of my own, and I'll leave it to you to decide who wants to go first in answering that, around the politics of surrounding changing regulation. Well, what are the politics? What can you tell us about the politics surrounding changing the code, changing regulation at national level, at state level, planning level? Who are the actors involved, the interest groups? What are the kind of sticking points that are at play here.
Maybe Shane, do you want to have a crack at that one first?
Yes, sure, absolutely. So from a building regulatory perspective, or the BCA, essentially the ABCB, or the Australian Building Codes Board, is made up of representatives from each state and territory of Australia. So they meet regularly, raise matters. There's obviously politics in terms of supporting one another's initiatives, and the matters, I guess, are processed and then become a document that's referred to the technical staff in the ABCB to do research on, and set up a case, I guess, essentially for change. Once that's agreed and ticked off, it goes through a regulatory impact statement, and then I guess is written into the BCA. However, in the BCA, there are also state variations. So some of the states can then opt out of those regulations that are in the body of the code, or they can add additional. There is I guess, a mandate by all of the states and territories to try and limit the state variations, because we're trying to get a national code here rather than a state-based code. But essentially, that's the process. And there are significant state variations that have been around since BCA first was adopted back in 1990 that continue to go on just because of the way that states operate differently. So from a national construction code perspective, that's essentially the process.
I might add with that, Ilan, that the building code itself, the BCA, continually is updated and changes. That's an ongoing process whereby changes are made, but they tend to be quite small technical changes. And to bring in major changes is a much more sort of onerous prospect and a time-consuming one. Took a long time for the fire regulations, for example, to change to allow for CLT timber buildings, structural timber buildings, for example. Despite the fact they've been built in the US and Europe for many, many years, but they were not allowed here under our codes. And similarly with accessibility into buildings, that's been a long process, which is, as Tony mentioned, is sort of ongoing now. I think it might have been Shane. We're sort of at the back end of that process now to make a decision. But building, by and large, is a risky business. It's expensive. And so major changes to regulations are always seen through the lens of, is this going to cost me more? And so then you have actors like the Property Council and people, bodies, master builders, who tend to be resistant to quick change, mainly on the argument that there are cost implications, where most of the politics is played.
Yeah, I mean, this is probably, I might comment as well. I mean, it might be something that Owen might want to comment in terms of industry groups. And I know the SDA Alliance has been important in advocating particular changes, because it's you need to bring together. I mean, if we went through the multitude of issues, and we've really just touched the surface, obviously, today in terms of the issues that arise. But you've got to have a centralised body to make it simple, or at least put it out in digestible form, so it's consolidated. Because governments aren't good, and certainly politicians aren't good at dealing with complicated issues at the get-go in terms of facilitating that change. So if you can. I think some of these industry body groups are really useful. I know that some of the states, my example before, I know a lot of the states are looking at Victoria and the way that they've dealt with the tenancy issues in particular, but there needs to be, and I'm not close enough to politics to kind of get how to facilitate this, but there needs to be greater coordination, certainly between each of the states, in terms of how these matters are dealt with. And perhaps, as I said, again, even if you just take tenancy, if some of the other states kind of look to that, I think there will need to be further amendments to the Victorian legislation, and at least they won't be the same. But even if there's a level of consistency between the way in which SDA has dealt with in each of the states, that would be really useful. But in terms of how we move that forward, I think legislative change is, again, a pretty slow beast.
Thank you. Owen?
I might jump in. Yeah, thanks, Tony. There's so many systems here that there's so many stakeholders. It's almost as if you want to address this properly, you have to take a fairly high level view, and you're going to bring in different stakeholders. If you put aside the state variances, which is an issue, as Tony said, just with our national system, we've got people with disability that should have a voice into this. We've got the building professionals. We've got, you know, safety around fire and things like that should be part of the discussion. We've got support provider safety. There's a piece of the discussion there. It's really quite complex. And I think what we're hoping with this project is that we can look at that complexity and say, here it is. Even at this point in time, we know there's interrelationships, but we don't know them all. And it's that desire to look at it holistically, to then say, how do we tackle this? And I think to do it well, I mean, we are chipping away at individual things, and there's really good work going on there. Tony mentioned the SDA Alliance. We're doing some good work with the Alliance, but I think we need a holistic approach.
Thank you. So just one more question for me before I turn to the QA panel, but there's I guess a question about, there's regulation that applies to all housing, to some what we might call mainstream housing, and then there's kind of disability, more specialist regulation. So I guess my question is whether if we increased or enhanced the minimum accessibility standards in the National Construction Code, would that reduce complexity by bringing, I guess, mainstreaming some of those standards, or would that increase complexity by just adding more layers of regulation?
I'll have a crack at that one first too, Elaine, if you like. Essentially, if I guess the problem is that each site is different in its own right. So by way of example, if you're building on the side of Mount Dandenong versus, you know, building on a very piece of flat land, access for people with disability is clearly a function of the topography of the land. If you apply a requirement that every dwelling, you need to get access from the roadway or say from a car parking space to the front door, that's going to be very difficult in a lot of circumstances. It's going to be very simple in a lot of other circumstances. So it is hard to apply a mainstream application, I think. However, I believe there's merit in what you say, in that we need to build in these fundamental applications so as people can either adapt the housing down the track, or it makes it a lot simpler for people with an access issue to be able to adjust and pick out, have a broader range, I guess, of stock, so as they can either lease or buy or whatever a particular dwelling in a particular area that is suitable for them, that they could either adapt or already has these facilities. So a good example might be that all bathrooms in a dwelling must have a minimum door size so that you can get a wheelchair through it, and that the walls must be fully lined with plywood or something like that, so as you can screw handrails and lifting devices no matter where you want them. Whereas currently, no houses have that. They have 10 mil plasterboard on the walls and you can't hang anything, you know, other than a photo of that, essentially. So I think there are some fundamental things that could be brought into just your basic class 1 dwellings that make them far more adaptable for the future. And as the stock turns over, we'll get a broader number of those, and, you know, people with access issues will have a broader scope for purchasing and renting, essentially.
Yeah, I'd echo that. I mean, I think not getting into the complexities, that I think in terms of the way that the NCC is applied, that I think, you know, Shane is much more across than I am. But I was focusing on SDA. We're not talking about you know, the other 94% of people with a disability who may, you know, some of them may just have an intellectual disability and may not necessarily require an accessible home, but a lot of them will. and then you've got people who are aging as well. And I think if you look at more decentralised care models similar to the NDIS, with home care packages and so on in the aged care space, I think it makes complete sense to have a more broad scale accessible home standard at a minimum level. And I know that, so we've got a son, we had a son with a disability, and it makes, it's really, really hard to find anything with the most basic level of accessibility in Australia. It's very, very challenging. So you tend to have to either go and build from scratch or massively or completely renovate an entire property. So I think the further we move towards that, or acknowledging the difficulties that Shane just mentioned, I think that ultimately should be the end goal.
Yeah, look, on one level, you sort of think, well, why would anyone build a house that discriminated against people? So why, we're a signature, as I mentioned, to the UN Convention on the Human Rights, on the rights of people with a disability. Housing is a human right. They're set out in that convention, and yet that convention has no practical effect on how we build. It doesn't impact us. Shane's not allowed in his role as a building surveyor to insist that the house doesn't discriminate, because the way the building code is set up, it doesn't allow that to happen. So that's one level of it. The other thing I'd say, though, is that we've had these kind of arguments before around 5-star and then 6-star rating for domestic houses, which was a fight that we had a little bit. But builders and developers and designers are, adept, and they solve problems. And so now we build houses at 6-star and it's not an issue for us, and it hasn't had a huge cost impact. But the benefits long term, not just to the person who builds the house, but the occupants over a 100-year period, are enormous in having a 6-star rating. And I think the benefits of having an accessible house that you could modify and get in and out of either will equally have a flow-on effects, multitude of times over the life of that house. So.
Thanks very much. I have a question here from Panita Thakur, and it's a question about disability access consultants. What is the role that disability access consultants play, I guess, in the Australian landscape, housing construction landscape?
So from a regulatory perspective, disability consultants generally don't touch on your class 1 detached housing. They will be involved in projects, apartment buildings, etc., because there's common areas and what have you that the regulations require access to. So they will be looking at circulation spaces, door sizes, ramps, etc. But for your general dwelling, an access consultant probably would not get involved unless it was going to be purpose built. And then, you'd probably engage an access consultant to apply their skill and knowledge of AS 1428, so as the dwelling actually had something that a person with a disability would expect and would have been trained to use.
Is that different from, say, the UK, where I believe access consultants have a much greater role?
Yeah, I'm not really aware of what happens in the UK, but most certainly for single detached dwellings, like your normal volume builders, they wouldn't know what an access consultant was, to be honest. Yeah.
Yeah.
Maybe I could just add to that, Ilan, for the category of SDAs, so the category of dwelling funded by the NDIS, there is a new role called an Sta Assessor. So in order to meet the design requirements for SDA, the building now has to be, or is going to fairly soon need to be certified by the Sta Assessor. And it's a role very similar to what Shane just mentioned for the access consultant.
Thanks. Thank you. And I've got a question from Diego Gonzalez Velasco, and thanks to Diego for joining us from Peru. I understand that the classification of types of housing which are being dealt with respond to the parcel established by the regulatory plan, which dimensions are the minimum required to configure an optimal architectural program. Which satisfactory response to current sociology and the morphology of the urban fabric? So I think the question here what are the criteria used to determine the building coefficient according to the existing zoning? Is anyone able to answer a question about, I guess, the criteria that's being used to determine building accessibility?
The classification, and Shane will back me up on this, I'm sure, or correct me if I get it slightly wrong. It is based on the expected use of the building. So it's the opinion of the building surveyor as to how will the building be used that determines the classification. Once a building has a classification, then there are a number of consequences in the building code that flow from that for things like fire protection, etc., etc.
Yeah,
But it's not a planning thing. It's a building code. Classification is from the building code, not from the planning system.
Thanks. And I think that also speaks to the, again, one of those complexities that we speak different languages across different jurisdictions internationally and I guess across states, which creates a whole lot of confusions. And that's part of the issue here, isn't it?
And just to follow up on that, in the hierarchy of these things, the building code sits higher than the planning code. So the planning code can't enforce something that goes against the building code in the layers of legality, if I can put it that way.
Yeah.
Yeah, that is the case for Victoria, Andrew. In other states, it's a little bit different. They have a more cohesive, what they call development approvals process, as opposed to independent planning and building. But you're quite right. They're two independent things here, essentially. And the building code is the technical aspects in terms of how we build stuff. The planning is really about amenity and whether you can have a factory next to a school and those sorts of issues, and densities and car parking and those other issues. But from an accessibility perspective, in terms of what a ramp should look like and a stair should look like, etc., is purely building code. Correct.
Thanks, Shane. Thanks, Andrew. A question from Edward Crossland. From a local government perspective, strategic planning, I'd be really interested to get a better understanding of what councils can do to facilitate more accessible housing options. So it would be good to get some clear guidance around this out of your work, or any guidance that you have now, and otherwise I guess it's also a request for your research to come up with some recommendations for local government.
Did you want to have a go, Owen?
No, we'd love to have a close working relationship with local government. There's some vagaries in planning law at the moment in Victoria that can be interpreted different ways. So I guess from a state level, not so much a local government level, some assistance to clarify those things would be really helpful, so that local government then doesn't have any ambiguity in how to interpret planning law. Tony, I don't know if you've got a view on that.
Yeah, I mean, again, not to, to be careful not to make this Victoria-centric, but that's what we're doing. Certainly in Victoria, as Owen said, there's a provision that is being interpreted in different ways by different councils. And so then you're able to develop, we're talking about SDA housing in Australia or Victoria, but you're able to kind of move forward without certain approvals on that basis versus other councils who interpret it in a different way. So there needs to be clarity. It's another example of where there needs to be clarity around that. And it probably, like Owen said, needs to be led from the state level.
I think part of the problem is it was written in a time of a different environment. It was written pre-NDIS and the world was different. And so the wording of it, so there's a clear intent with the legislation, but just the way it now happens is it can be interpreted differently. So that clarity would be great.
I know we learned from one of my previous projects when we were looking at how do you design townhouses that were more accessible and included an accessible bedroom and bathroom on the ground floor and not up the stairs of a two-story townhouse. And one of the issues that came up was the requirement in some cases to have a car park garage. And so that just squeezes the amount of space on the ground floor and you just can't fit things in. And so it's traffic coordination at council level that's stopping certain parts of the development actually having downstairs bedrooms. And so these things can come in from kind of strange directions at time and have an impact on what you can do.
So it sounds like part of the answer is reducing some of those excessive requirements and then also providing incentives to develop accessible housing. Is that sort of two directions for the answer?
Yeah.
But it sounds like you're not suggesting adding further regulation on top of the existing complexity.
Well, the BCA may well be amended, by 2022 to include accessibility into Class 1 houses. So there's the possibility, which I think would be a good thing. There is a possibility of extra regulation. In some ways, it's not that there's too much regulation. It's that the regulation doesn't speak to other regulation from different areas. And so you get unintended consequences that block or give perverse incentives to go down certain directions that are not actually part of the original idea of that particular bit of regulation. And so it's the interaction of the different ones as opposed to there's too much regulation. I think housing's too important, to be honest, all housing, to be left without regulation. You wouldn't want a free-for-all in that sense. And so it's the coordination and the clarity that is the big issue, I think.
The clarity, if I could just add, the clarity is so important because the different interpretations at the moment are leading to vastly different build forms, and we don't know which is right and which is wrong, but we do know that some are developing, far in excess of what they should potentially, and others far under what they should. That clarity is so important.
Thank you. And I guess another question for me, and that's something that came out from discussions around consultation around a minimum accessibility standard for the NCC. And some of the arguments put forward by the housing construction industry is that there is no demand for accessible housing. And that if there was demand, they would have built more accessible housing, but the demand hasn't shown itself. So I'd be interested to hear your perspective on this position.
I think it's rubbish. Having gone, I can only speak from a personal perspective, but having gone through the process of, and once you become a part of that community, certainly, whether you're elderly, you need something more accessible, whether you're a person with a disability or whether you've got a child with a disability, I don't think it's a demand issue. There just hasn't been, and this is probably one of the good things coming out of the NDIS, but there probably hasn't been enough of a voice to push for these kinds of changes. But there's absolutely a demand, because if you speak to any, certainly, again, from a personal perspective, we've been friends with a whole bunch of other families with a child with a disability that just can't find a house that's appropriate. And then there's never been a central database to find something that's appropriate, so you don't have to renovate a house and you've got to find a flat block of land. And I just don't think there's been enough of a voice within that community, and probably until recently, a pretty disenfranchised community. So, and there will be additional costs. There'll be additional costs, and there are probably people better than me to talk to that on this presentation, but there may well be additional costs associated with building an accessible house, and so the incentive is not going to be there to actually do so. So it kind of needs to be, certainly if you look at STA, where there is enough of, like actually in some cases, a massive financial incentive to build certain types of accessible homes. The sector is, there are a lot of people throwing their money into that sector at the moment because the financial incentive is there. So you need to create enough of an incentive to do so, and that can only be done either financially or otherwise through regulation. But there is absolutely demand there, and I'm sure there are plenty of studies out there to support that.
Yeah, and demand is a funny thing in the housing market. On the surface, it's very much, it works beautifully from a free market point of view. There's suppliers and there's demand, and they meet in the middle, and there's a price. But most people, the vast majority of people who buy or rent in a dwelling, buy an existing dwelling, or they buy something that effectively comes from if you're buying in a greenfield site, for example, that design's already been done. There are very few changes you can make. Only a very small percentage of people hire an architect and build the house they actually want. So, but everyone still has to live somewhere or rent somewhere, so they take what they can based on how much money they've got and what they can afford. So the idea that there's no demand because people aren't asking for it's not quite right. It's that there's no choice around, so people have to settle for what they can best find. So that argument, I agree with Tony. I don't really buy that argument. There's no demand for this.
Thanks. Thank you both. I've got another question here about, given the benefits of accessible housing features, that they extend beyond those only with a disability, taking into account aging in place and multi-generational households, etc. What are the panel's view on the potential impacts on housing affordability as a whole if minimum accessibility features were mandated in the NCC? So a question here about the relationship between accessibility and affordability. Any views?
I can jump in and say that I think the market will respond as it would with energy ratings when they came out, and the cost will be negligible. It does depend at the level of access that's added, but I think in a free market we'll find that it'll be those costs will be negligible and the benefits enormous.
I would agree. I would think, I'm not a quantity surveyor, but I would agree that the long term, the cost will be negligible, because as builders become used to building in certain ways, product manufacturers develop and respond with that. As that happens at scale, and building is a very large industry, it happens at scale, and so costs and prices come down as people are more familiar with it. The change probably has an initial spike, but then it settles down, and over time, the cost for particularly basic things like accessibility should be pretty negligible, because there will almost certainly be certain exemptions for, as Shane mentioned, very steep sites and things like that where it will be cost prohibitive. But for the majority of dwellings, it should be easy for the industry to respond to it and to have it sustainable over the long term.
Yeah, I agree. And I think there are, in some cases, depending on I think people have a particular view of an accessible home, but in a lot of cases, just turning circles and things like that, and it just creates additional space, and it can actually make it quite a livable place. So it can make it more livable, and arguably it could add value to it, putting aside the fact that people might pay premium because it provides those amenities. There's arguably an argument that it's actually just a nicer place to live, and there's a value just attached to that alone.
Thanks. I do have a follow-up question though about exemptions. So if there was regulation about applying a higher minimum accessibility standard, and say you had a house that's being built on a slope, is it very difficult to just introduce those types of exemptions into the legislation, into the regulation?
Look, Alan, I think the process, it would have to be really prescriptive, because otherwise, it becomes an interpretive thing. And as Owen's already discovered, even with the current regulations we've got, he's getting different interpretations from different building surveyors. So, it would have to be very prescriptive in terms of, if your block is more than a 1 in 15 fall or something like that, then you obtain an exemption or whatever the case is. I mean, I don't know what the numbers would be, but I think it would have to be prescriptive in that sense, so as there's really no arguments or no pressure to be brought upon the building surveyor to sort of make this judgment call as opposed to a strict interpretation of the written law, essentially, which, you know, is a lot clearer and easier to apply. But look, I think there's provision for exemptions in there, and they could even be delegated back to the council. We have siting requirements now in terms of how close your house can be to the front boundary. And, you know, if you can't build a building because of a certain reason, you can apply to the local government and get a dispensation on that setback. So I think the exemptions probably would sit with a quasi-government authority like that, where you wanted to move outside of the requirements.
Thanks. Another question from Panita Thakur. Why do we just have houses for people with disabilities with one bedroom for their use and another bedroom for a carer? Don't you think they should have choice to stay with families and should get help for that? What are the assumptions around the houses that are being built for people with disability? Especially, I guess this is also a question about SDA, the assumptions that are made about the types of living arrangements of people living in these homes. Probably a question for you, Owen.
That's for me, yeah, I think it is. I think the market's responding to the framework that's set in place. It's such a complex area to decide on what to develop. I completely agree there should be more opportunities for families to share, but the framework at the moment doesn't kind of encourage that. So I think it would need a review of that SDA framework to encourage that to happen more.
There's also there's a range of housing type that's required. One large issue is that people with disability are often effectively forced to live in their parents' place because they can't find places that are appropriate or that have the facilities that they need to be supported. And so that first step out of the family home into a small single dwelling thing is a step away. You know, that would be very beneficial for a lot of people to be able to move out of the home into a small space that was yours. But equally, there will be people who want to move out into a rental place with some of their friends as well. I mean, everyone is different. There's a variety there. But there's not many of those very small, tiny places available that are appropriate. There's plenty of one-bedroom apartments in Melbourne, but that are appropriate for people with a disability. So that's why that sort of model, that will have come out of a particular demand that the Sum of Housing had established.
Thanks. Thank you. So I've got an interesting question here from Paulo Valsera about conflict of interest with building surveyors and whether the fact that they serve the clients as developers and builders, whether that creates a conflict of interest. I guess that's for you, Shane.
Hey, yes, sure. I mean, this is always a question that raises its head, I guess, when we have a private system of controlling regulation. So up until 1994, you had to go to local government to get a building permit to construct a building of any particular class. But then that was fully privatised in Victoria in 1994. And from that day going forward, there have been people criticising, I guess, the likelihood for there to be a bias between the building surveyor and their client. Now, essentially, building surveyors are all professionals. We're regulated. We're audited regularly. I mean, I think from my experience over 30 plus years, no more than now are we under the microscope of the government, essentially, in terms of how we practice. We have a code of conduct that we have to adhere to. We have to be registered, obviously. We have to provide insurance. Currently in Victoria, we don't have to maintain CPD points, but they're coming. I think they're all good initiatives. Essentially, you know, it doesn't matter whether you've got a local government building surveyor or a private building surveyor. They're humans and they act professionally. And I would support the notion that if the regulations are clear enough and there's, you know, not that room for interpretation, then there's no room for bias either. You just apply the regulations as they're written. But you know, clearly, no system's perfect. But I'd like to say that the private system in Victoria in fact, encourages people to seek building surveyors that are experts in the particular type of developments that they deliver. So consequently, I don't do a lot of single dwelling houses in my role. There's plenty of other building surveyors know a lot more about the timber framing manual and the footings code and all those sorts of things. My expertise lies in multi-storey residential, large public buildings and those sorts of things. Now, in the old system, if someone was going to develop that in Ballarat, then they had to deal with the local municipal building surveyor in Ballarat that might have 95% houses and done the odd sports ground or something like that, but would not have come across a building over 25 metres. It comes with a whole heap of other fire complexities and what have you. This system actually allows you to seek out a building surveyor that knows what they're doing and can apply the law, correctly. So my view is that the current system really is outside of being corrupted, I guess, is probably my view. Yeah.
Thank you. I'll just read one comment from the QA from Heather. I think that's in response to the question we've had about local government and a potential role for local government. Sorry. Banyule City Council planning encourages 1 unit per development of 3 units townhouses to be designed to be accessible, door width, bathroom dimensions, ramps to front doors, bedroom and ground floor, or capable of being fitted in the future. Unfortunately, it's voluntary. We're promoting it to the developers, architects as a benefit for their selling potential, such as aging in place, and it's cheaper to do it as part of the development now. However, it's voluntary, and we've had cases at VCAT remove the conditions, so all we can do is encourage.
Yes, look, I certainly have a view on that. I think it's commendable. I think a better approach, though, would be making 100% of the dwellings adaptable for later improvements for people with disabilities, depending on the level of access required. The problem with actually saying that you need 4 in 100 or whatever is that those 4 may not sell to the people that require them. Somebody might buy those units that just because they like the view, and then that precludes another buyer that actually needs it from having it. So it's limited in a sense that once they're snapped up, they're gone. But if we apply a more general, accessible or adaptable accessible approach across the whole development, then it doesn't matter which one you buy. You can buy the front one, the back one. It's adaptable and you can actually make it suitable for your disability. Yeah. So, but I think it's a commendable thing, but it's very hard to police. And as you say, it's voluntary, and VCAT just tend to throw it out because there's no legislation to support it.
Thank you. I think we are running out of time. So on this note, positive note, I do want to thank our 4 panelists, Shane, Owen, Andrew, Tony. Thanks so much for your input today. It's been wonderful to have you here. Thanks to all the attendees. Wish you a good night.